A local case in Emerald Isle has been offered to the North Carolina Supreme Court related to an appeals court decision over private property rights and particularly rights on the beach. And we have joining us this afternoon David Breemer, who's representing the family. He is a principal attorney for the Pacific Legal Foundation. His area of expertise is property rights and coastal land rights. And so with that, David, good evening. Thanks for taking the time to be with us. We appreciate it.
Thanks for having me.
Let's talk about this case. We've seen this case covered in local newspapers. A family is contesting the privileges that have been awarded by the town of Emerald Isle to folks to basically drive on and utilize property that is, well, within the boundaries of their deed, I gather, all the way to the high water mark. And the Neese family contest that the city nor the state have the right to prohibit their use of their property in a fashion that they wish to use, but at the same time giving privileges to folks who are ostensibly the public. Am I pretty accurate in that description?
Yeah, yes, as a general matter, there's some background knowledge that really helps understand this case.
Okay.
And that knowledge is this. When the states of the United States came into the Union, at different times, but whenever the coastal states came into the Union, they took title to all the land that was the king's land, all the land that was in the king's domain.
Okay.
And under the old common law dating back to England, law that was unwritten law basically, but practice and it was a custom, the king owned the seashore. Okay, so the question becomes, well, what is the seashore? Where does it end and where does it stop? I mean, where does it begin and where does it end? And what the courts of this country have decided is that the seashore that's held by the sovereign, it used to be the king, now it's the state, ends where the tide ends. Okay, well, where does the tide end? The rule in this country, by and large, for almost every coastal state, is the mean high water line is the boundary between government-owned seashore property. Private property owners don't own the water. The tide lands on the water over them. The mean high water mark is the boundary. Anything inland of that mark is private property and can be sold and disposed of and used like any other property, but anything going toward the sea from the mean high water mark is state-owned tidelands that have to be held in trust for public use. That means although the state owns that property, the land below the mean high water mark, it can't just get rid of it like it can property that's in the desert. It could just sell off whenever it wants. It can never... It could sell that land, but it can never get rid of the public's rights in that tideland, because tidelands are so useful for navigation, for fishing, for commerce. So that's called the public trust doctrine. The state holds land below the mean high water mark in trust for certain public uses. Okay.
Now, with that said, North Carolina has for years always identified the public land trust. Well, let's correct that last. They have made available to public use the beachfront from the high water mark to the primary dune. As a matter of fact, that has been one of the areas of contention, the justifications and identification of the primary dune. But it also has, I gather, still given, if you will, under the deed, the acknowledgement that the property from the main primary dune to the water is described in the metes and bounds of the real estate. Am I correct on that?
Yes, let me clarify. Okay, so in North Carolina, like most other coastal states, the private property ownership goes to the mean high water mark. The mean high water mark is the average of the daily high water tides over 18-year period. So you cannot see that mark. It has to be surveyed, okay? But it's close to where the wet beach is, all right, where the high tide comes up. So it's undisputed that in North Carolina, if you own dry beach property, when you see dry beach property, that starts out as private land. It's not state-owned property. It's not public property. State-owned property ends at the mean high water mark. So what's going on in this case is that the town said, well, we think the public trust beach that goes to the dunes, it doesn't stop at the mean high water mark. We think it goes inland. So because, yes, you own that property, they say to the Neese, but we can do whatever we want. You hold title and pay taxes on it, but it's our property to do with whatever we want. It's public property. We can drive on it. We can go on when we want. We can park on it. We can sell permits for the public to party and park on it and put their trash cans on it. And the Knees have said, you can't do that. That's private property. You've never bought an easement from us. You've never bought the property from us as the Constitution requires when you want to take private land. And the dispute is largely about that. Can the government come and take dry sand beach property on the theory that it's part of, that even though the private property is owned title to it, that it's secretly part of this public trust beach that's limited to the wet beach area.
Now, you use the word secretly. I will say that it is an understanding, and as a local resident have always acknowledged the fact that while the property owner theoretically, I use that term, my description, not yours, owns the property from the primary dune to the high water mark, and I think the vast majority of the residents of North Carolina perceive that portion of the beach as being public trust. Is it not?
Well, that's where we have a problem here. Okay.
Okay.
And that's why this case, it's a little bit
This is technical.
There's some legalese, okay?
Right.
So I have to clarify. There are ways that the public can gain access to dry sand beach legally, okay?
Okay.
If the public walks over a certain area for a number of years, usually 20,
right,
against the owner's wishes, it can acquire what's called a prescriptive easement,
or
just like an
or adverse possession, as it were.
That's the same thing.
Yeah.
Okay. Mm-hmm. But the thing is, in order to get that sort of easement, the government or the public has to go to court and prove a number of facts for each parcel that it says that it has an easement. Okay.
Okay.
So that's one way. You can also get access if the private property owner dedicated their land to the public, either by overtly or by implicitly by consent, just basically gave up on it and implicitly donated. Okay, but that too, you have to go to court and prove it parcel by parcel. And finally, you can have consent. The property owners can just consent and give permission for people to walk over that. That doesn't just transfer title to anybody, it's just permission. The problem is here. What the town is trying to do is trying to get around all the normal legal avenues for gaining access. You either buy land, you prove an easement in court according to the law of the land by just saying, well, we think this is public trust. In other words, the public trust part of this issue matters a lot. The public trust can't just be expanded by government, by fiat. Mm-hmm. Why not expand it to the first public road?
Right.
Why not expand it? Why not expand it to two public roads in? Because we live in a society that's based on the rule of law.
Right.
And so if they want to acquire access to private land, which everybody agrees it is, there's the right way to do it under law, and then there's the shortcut. The town doesn't want to go to court and prove on every parcel that it's public. They don't want to buy easements. It's expensive and time-consuming.
All right. With that said, I want to go to something very quickly with you, David, because we're running out of, we got about 5 minutes. But by the way, David Breemer, our guest, and he is a principal attorney for the Pacific Legal Foundation. And I've got to give you time, David, to explain what the foundation's about. But back to this issue related to the Knees property, and this is a family in Emerald Isle, North Carolina. David, recognizing that it has been an understanding for many years in North Carolina and some an expectation and anticipation, if this case is being heard by the state Supreme Court, and of course that's where the next level, is there a potential that the decision on this case may impact property ownership along all the beaches of North Carolina, or is this unique to only Emerald Isle and particularly this parcel of property?
Well, it would have more far-reaching effect. If the Knees won, it wouldn't end public access. What it would do is require the government to go through the normal constitutional processes to when it wants to impose access. Let me briefly address you said several statements that the public assumes, the public expects. Okay,
Mm-hmm.
All right. And I understand that, but you have to go back, okay? Just because there's a tradition or an expectation, you have to go back and say, where does that come from?
Right.
You know, I might expect that I'd walk across your property and you never stop me, okay?
Right. Mm-hmm.
That doesn't make it mine. Part of the problem here is that the local governments, and to some extent some state governments, not always, have been telling the public that this is your beach, okay?
Right.
And so the public, if the public has an expectation that this is their beach because they've been told it, that's not the property owner's fault. Okay. The property owners, for some of them, they might not even know the property is being taken. But the town doesn't dispute that this is private land. It's always been private land. There's no easement on their title. They haven't tried to prove it. They haven't offered compensation. They haven't asked permission. All they say is, we're going to define this as part of the public trust beach. You can't take private property that way. If you can, then no property is safe.
Right. With that said, let's look at what's the procedure here. Now, of course, the appellate court has decided in favor of the town/city of Emerald Isle. You're requesting, or the family is requesting, a review by the Supreme Court. What is the procedure for this? Is this on its way, or is there something that has to happen before the court will take up this case?
The court has to decide whether to take the case, and it will do that. We don't know exactly when. It could do that at any time. However, it's most likely to do that in late January, late this month, at the end of this month, or in March. Once it decides, if it decides to take the case, and I believe it will because it's very important, but if it decides to take the case, then we'll have to rebrief the case. The old opinion from the Court of Appeals would be nullified, and we would rebrief the case, and then there's going to be another period of waiting, could be up to a year for a decision. The one other thing, I know you got to go real quick. I want people to think. What people to think about is this. Okay, part of the problem with this whole using the public trust theory to say, well, all the dry sand, it's privately owned, but it's all public. It's private, wink, wink, but it's public because of the public trust. The problem with this, okay, well, what happens when a storm or erosion moves those dunes or that vegetation back? What the town is setting up is a system in which the public beach never loses ground, and in fact gains ground by moving inland and swallowing private property. So right now we're talking about first row houses, okay? But if erosion continues and there's storms in that vegetation line, remember, the town says that the public trust beach doesn't end at the mean high water mark. It goes all the way to the dune or vegetation line. Those things are very susceptible to weather-related changes. They can move in drastically. So you get a storm that moves them 30 feet inland, and this did happen in 2011. The town just says it moves 30 feet from an area where the public may be using to an private area where the public has never been. The town says, well, that's public. It magically overnight turns from private to public property, even though the public has never used it.
But the other side of that, David, is those instances where the public provides beach nourishment and therefore adds to the real estate of the property owner. And I know that we've had a circumstance, I think, in Texas and Florida.
No, they don't do that. It doesn't add to the property owner. When in North Carolina, when you add beach renourishment, and nobody's challenging that, when you add beach renourishment sand, the state adds it below the mean high water mark. Why would they do that? Below the mean high water? Because they know, because that's for sure state property. So when you dump sand on a wet beach area that's below the mean high water mark, that is not part of the property owner's title. That stays with the state. The property owner gets nothing. So this is a one-way ratchet system in which the town is saying, as soon as a storm moves the vegetation line in 2 feet, 10 feet, 20 feet, and turns your vegetated property into sandy property, well, it's dry sand now, so it instantly becomes the public's. That's its position.
David Breemer, our guest. David, the Pacific Legal Foundation, very quickly, this is an organization that will provide support or actually representation at no charge. Am I correct on that?
We don't charge attorney's fees. We represent property owners all over the country on a pro bono basis in precedent-setting cases to level the playing field with government who have taxpayer-funded attorneys.
How do you decide cases that you're going to select, and how is the Pacific Legal Foundation able to afford this? So those are the two quick questions before we wrap it up.
That's a great question. We're a 501c3 foundation. We're nonprofit. We're a charity. We're a charitable legal foundation. The ACLU, there are other ones. We're similar in some respects to that, in which we get lots of requests for our help because property owners get run out of money when they fight the city hall, when they fight the government. And our board of trustees takes these requests and selects the ones that we think we can help in the best way possible, and we use the donations that we receive to pay for these lawsuits, and at least for the attorney part of the lawsuits.
Okay, and you've worked in this area for some time. You've been involved in several major cases. I see one here, the town of, you defended Sansota, I guess that's a family, versus the town of Nags Head, city and county of San Francisco, Levin versus the city and county of San Francisco. Is this a growing field as more people move to the coast? Are we seeing more interest in these kind of cases?
Yes, I mean, just property rights in general. Okay. There's a bigger government. It's not like there's a shortage of work in this area, and certainly there's a lot of conflict on the coast because there's competing demands for a limited supply.
Okay.
Public and property wants this coast. The Sansota case, by the way, in Nags Head, once the vegetation moved inland of his house, the town came and said, well, your house is now, you built your house on private property, but it's now on public property, so you have to move it.
Yeah, the vagaries of both nature and government, when they come together, can make for an interesting issue and obviously interesting legal cases. David, thank you very much for being with us. We appreciate your time this evening. Look forward to future conversations.
Thank you for your time. I appreciate it a lot.
Our pleasure.